Welcome back, everybody. Thank you all so much again for spending your day, or at least part of your day, with us. We really appreciate it. Thank you again so much, exquisite panelists, for giving us so much to think about today. It's been a wonderful day. And we are already at our last panel for the day, entitled Compelled Speech and its Sociopolitical Implications. So to start us off, I will turn the floor over to our moderator for this panel, Professor Kenneth Dau-Schmidt.
Unmute. Thanks, Caitlin. I'm very pleased to be here today. I had a wonderful feast today of First Amendment discussion of First Amendment rights and responsibilities. Certainly the Harris lecture by Professor Post was very worth listening to. Today, this last panel is going to talk about compelled speech and its socio-political implications. And I am unmuted, right? Yes. And we have two colleagues that I know very well. Charlotte Garden from Seattle University School of Law. She'll address us first. I'll introduce her in a minute. Then we have Catherine Fisk, University of California at Berkeley. She's a co-author of mine. We the three of us often see each other at labor and employment law panels, and they're both going to touch on the Janus case, which as Catherine points out, is a fundamental case on this topic, and was handed down within hours of the NIFLA case that, of course, is the seminal case. And then Jane Bambauer, who I don't believe I've had a chance to meet. I gave a presentation out at Arizona back when my good friend Gene Braucher worked there, but I think that was before Jane's time. So, but I'm glad to meet her even by Zoom today. I wish this was in person. But let's start first with Charlotte, who's going to address us on workplace subsidies for speech and religion.
Great, thank you, Ken.
Let me remind you of one thing. You each have 20 minutes, and I'm supposed to watch this closely to try to make sure we have time for questions at the end. And Steve is going to keep track of questions in the chat. So go ahead, Charlotte. I'm sorry to interrupt.
No, thank you. So this has been such an enjoyable and interesting day. I'm grateful to the student organizers, especially Caitlin, and also to Caroline and to Alex for convening us. So my talk today is on a set of cases that create what I'm sort of loosely calling accommodations for speech and religion at work. These cases allow the costs of accommodations to be shifted onto identifiable others, so that the accommodation benefits an employer or a group of employees, and other employees end up bearing or potentially bearing the costs. So I'm taking a little bit of liberty with the theme for today's symposium, but you'll see that the topic ties into compelled speech in a couple of ways. So we've heard about some of the cases that I'm going to be talking about already today, especially Janus. I'll keep this part of my talk short, but just to set the stage, I wanted to kind of explain some of the material or some of the cases I'm talking about. So first, Janus v. AFSCME, which held that public employees can't be compelled to pay money to the union that represents them. Janus has the practical effect that pro-union workers and unions themselves now subsidize objectors' exercise of their First Amendment rights not to pay their share of representation costs. And effective public sector union representation then depends on whether a sufficient number of workers make individual decisions to pay union dues when they're not required to. And second, there are cases including Hobby Lobby that we've heard about today on the ACA's contraceptive coverage mandate. And those cases allow employers who have religious objections to opt out of covering employees' access to contraceptives. And then finally, cases on the ministerial exemption, which hold that it would violate the First Amendment's religion clauses for courts to order a religious employer to reinstate a ministerial employee, even if the employee was fired in violation of discrimination law and not because there was some problem with their ministering. So last summer, the court broadened the definition of who counts as a ministerial employee, and its decision put weight in part on employers' descriptions of employees' roles and duties. And those cases allow employees to be deemed ministerial, even in cases where the employee didn't understand themselves to be ministerial, the employee didn't have any special religious training, and the employee may have just happened to come work for a religious employer, right? I'm thinking of, a new teacher who applies to both religious and secular schools. They get hired by a religious school. They take the offer because they need to eat and pay their rent. In other words, they've accepted the job not because of the school's religious character, but in spite of it or with indifference to it. So there are a few significant things about these cases. So first, the idea that individuals and businesses can be entitled to shift costs of religious exercise onto non-believing employees or in ways that generate competitive advantages for the business is new, as people like Elizabeth Sepper have written about. And then the move from Abu to Janus reflects kind of a similar shift in terms of cost shifting. There may be a little more ground to travel in this regard. In last summer's Little Sisters of the Poor case, which approved the Trump administration's authority to adopt rules exempting employers from the contraceptive coverage mandate on conscience grounds, Justice Alito, joined by Justice Gorsuch, wrote that there was no requirement that an accommodation of religious belief be narrowly tailored, even if the accommodation means that some employees won't be able to obtain contraceptive coverage. And that such an employee isn't even being burdened, but is instead, quote, simply not the beneficiary of something that federal law does not provide. And then the other dynamic I wanted to talk about here is that in Janus and in the ministerial exemption cases, the court found an accommodation is owed, even if there isn't actually a clash between ideology or religious belief and a legal requirement, right? So employers in the contraceptive coverage cases still have to assert that they object to the contraceptive mandate. But as Jesse was talking about, Hobby Lobby models like a pretty cursory review of even that assertion. So, I disagree with these decisions, but, here we are. Given that reality, I wanted to think through some of the potential kind of responsive measures that might be taken to mitigate the burden that these accommodations impose on employees. Especially in the context of Janus, there has been a lot of thinking in unions and in state legislatures and by commentators about how to blunt the effects of the decision on unions and their members. Instead of talking about those specific proposals, though, I wanted to talk about kind of categories or types of strategies, with the idea that approaches in one context could be usefully considered in other contexts as well. And I should acknowledge that all of these potential approaches have benefits and drawbacks that are unique to the particular circumstances, the particular accommodation. Okay, so the categories as I see them are, first, the government pays. So the government takes on the cost of the accommodation. Second, the employer has to provide some kind of notice or additional information about the existence of the accommodation to allow for informed decision-making and other responses by employees. 3, employees engage in self-help, possibly on a collective basis, possibly on an individual basis, and government does things to make it easier for this to happen. And then 4, reducing the competitive advantage to be gained by invoking the accommodation in situations where there isn't actually an ideological or religious conflict. So I want to talk a little bit about what each of these categories is, why the category might be useful, and some of the category's limitations. None of them, right, completely eliminate the cost to be borne by other employees, right? They sort of do that to varying degrees, some very little. Okay, so first, the government pays strategy. So this is a strategy that the court itself identified in Hobby Lobby. The court relied on the fact that government could provide access to contraceptive coverage as a basis to say that there was a less restrictive alternative to requiring religious companies to provide the accommodation. And it's also a strategy that got some discussion in the wake of Janus, although the main public sector unions have strongly disavowed the idea that they could ever want to become publicly funded entities, generally because of the risk of actual or perceived government capture, right? These unions don't want to become what is known in labor law parlance as dominated unions. I'm not aware of government pays proposals that are linked to the ministerial exception, though, but you could certainly imagine some kind of enhanced unemployment benefit when people lose not just their jobs, but also their opportunities to prove that they lost their job because of a protected characteristic. And especially because people who lose their jobs because of a protected characteristic may also face discrimination when they try to get new jobs. an approach like this could also, undo or mitigate some of the just immediate tangible harm to employees that the ministerial exemption can bring about. The drawbacks, or at least the incompleteness of this approach, are evident, right? Government substitution isn't seamless, as Justice Ginsburg put it in Little Sisters of the Poor. There are some other context-specific disadvantages, right, like the ones that public sector unions identified in Janus. Okay, so the second category, notice and informational remedies to allow people to try to protect themselves. A version of the strategy is already being deployed in the union context in a number of states in response to Janus and decisions that preceded it. Some states adopted laws guaranteeing unions an opportunity to educate workers, upon hiring or sometime during their tenure about what the union does, right, and to make a case for membership. It's also a strategy that some scholars have proposed in connection with masterpiece cake shop type rules that allow businesses to refuse service to members of the public based on their sexual orientation or other protected characteristics. I think there's a case to be made, maybe not an incredibly strong one, but a case that it could be useful for employees who are subject to the ministerial exemption as well. So consider Cheryl Parrish, the teacher whose firing led to the court's decision in Hosanna Tabor. Parrish developed narcolepsy, and she went out on disability leave at the beginning of the school year. In January of that same year, she let the principal know that she'd be able to come back to work the following month. So far, so good. But this is where things start to go wrong. The principal had hired a full-year substitute teacher, and maybe because of that, right, maybe he doesn't want sort of double coverage, or maybe he doesn't want to fire the substitute, I don't know. The principal begins to express doubt about whether Parrish should return, and eventually the principal offers to pay a portion of her health insurance premium in exchange for her resignation. But Parrish stands her ground. She goes to school on the day she said she could return to work. She demands documentation that she had reported. She tells the school that she's consulted an attorney and she's going to stand on her rights, and then the school fires her. So Parrish's actions leading up to her firing are the actions of somebody who believes, right, reasonably, that she'd be able to rely on statutory employment protection for disabled workers. If someone in Parrish's position were aware that the school intended to take the position that they were a ministerial employee, that this was a category that Supreme Court law recognized, and that if the school were successful, that they wouldn't be able to obtain legal remedies for employment discrimination, they'd at least have important information about their situation that might guide their choices about things like what they say to their employer up front, how and when they notify employers about certain sort of life situations, how they approach the employer, how they go about having those conversations. The notice, right, isn't actually improving not improving the employee's options here, right? Employees who are in situations like the one Parrish was in still have bad options, but at least they'd have a better chance of being able to kind of confront them strategically. In a way, I find everything I just said to be like incredibly depressing, because it's basically saying that employees should know that they don't have recourse to key rights, so they can like strategically avoid trying to make their employers angry. But it does seem better than flying blind. Maybe slightly less depressing. Some workers, though of course probably only relatively privileged workers, might be able to contract up front with religious employers about some aspects of the ministerial exemption, right? They might seek assurances about their treatment in certain foreseeable situations. They'd only know to do this, though, if they first knew that they might be covered by the ministerial exemption. And that knowledge could also spur collective action, right, which I want to talk about in a second. Okay, of course, there are all sorts of drawbacks. One is that a notice requirement might be deemed by a legislature to violate the First Amendment. For reasons Alan and others were describing this morning, right, there's a chance that just the bare notice requirement, just you have to tell people that they might be ministerial, might violate the First Amendment, although I don't think that's very likely even given NIFLA. The harder question, though, is what the penalty would be if the employer fails to give the notice. So the court has referred to the ministerial exemption as an affirmative defense, which suggests it can be waived in litigation. But at the same time, it seems unlikely that the court would allow, or at least the current court would allow, the remedy for failure to disclose that an employer thinks an employee is ministerial to be that the employer is then deemed to have waived the ministerial exemption defense altogether and could be forced to reinstate what the court would call an unwanted minister. So we'd be talking at best about kind of more symbolic remedies, which might not, have much, the employers might not have much of an incentive to comply. Other drawbacks include the likelihood that a notice about an employee's potential ministerial status would suffer the same problem as many other required notices. It's on page 50 of the employee handbook. It goes unread or ununderstood, or even it is read and understood, but it's not believed, as apparently sometimes happens when employees read individual arbitration clauses. And there's the possibility that an employer would cynically or mistakenly over-designate ministerial employees, with the possible result that employees who could bring claims and who couldn't reasonably be thought of as ministerial might be deterred from going to court. Okay, so next, self-help and collective action. So employees might be able to blunt the effects of these decisions, these accommodations, on their own working conditions through individual or collective action. Catherine Fisk, who's speaking next, has pointed out that one response to Janus is one that unions and employees undertake themselves, a combination of membership incentives that unions can give and social norms that unions and employees can develop to make it socially unacceptable to benefit from a union's representation without paying your share. And union access and education laws that I talked about a few minutes ago, right, help undergird and lay the groundwork for this strategy. Similarly, legislatures might think about, sort of generally how to increase employees' own power so that they can resist when they're treated badly by an employer, whether that employer is religious or not. The prospect for employee resistance and social outcry when an employer does something like fire somebody because of their protected characteristic or refuses to provide the full complement of otherwise required insurance benefits, right, might in some geographical areas, probably more than others, right, might serve as a check on the employer's choices. However, right, the usual dangers and challenges accompany workers' collective action, and those challenges are amplified in the case of the ministerial exemption because those ministerial employees will also lack reinstatement rights under the National Labor Relations Act, which usually provide at least limited protection for collective action and collective bargaining. Okay, finally, reducing the competitive advantage. So in other work, I've talked about what a strategy like this might look like in the context of religious employers' exemptions from collective bargaining obligations. Strategies like this are relevant because employees in the union context and employers in the context of the ministerial exemption can invoke the relevant accommodations, right, without there being this ideological or religious clash. Right, the risk, of course, is that some will seize upon the exemption for financial reasons, not for ideological ones. This could be avoided if, for example, a union objector has to pay the equivalent amount of money to a charity, which is what happens when you have religious employees who object to paying union dues in the private sector. Professor Sam Estreicher has argued the same approach would be useful in the public sector, though Catherine has pointed out some administrability problems here. One can imagine what this would look like in the contraceptive coverage context, and one could even imagine some kind of sort of similar approach in the ministerial exemption context, though there you can, of course, imagine the inevitable legal challenges to requirements that religious employers compensate their employees for their lack of access to employment discrimination law. Okay, I think I'd better stop there, but I am looking forward to the rest of the discussion. Thank you.
Thank you. Thanks, Charlotte. We're going to get a chance to ask questions of everybody, but we're going to go through all the speakers first. So we're moving on to Catherine now. Catherine, of course, is going to talk about complicity and compulsion in the workplace. Go ahead, Catherine.
Thank you very much to everyone at Indiana University for all the work you've done on this symposium, and of course to Alexander and Caroline for creating it and inviting me to participate. Disclosure requirements imposed on providers of goods and services, we have heard many times today, are a longstanding approach to regulation for a very good reason. Disclosure provides information to consumers of goods and services at the point when the information is most likely to enable informed choice. Some mandatory disclosure laws require speech from one person, not only because of the consumer's interest in receiving it, but because of the public interest in preventing misleading or illegal behavior by the speaker or by the hearer or a third party. Or they do so to help consumers know their legal rights. Disclosure requirements in employment law, including under the Federal Family and Medical Leave Act, the Employee Retirement Income Security Act, the WARN Act, enable employees to know their rights about family and medical leave, health insurance, retirement benefits, plant closures. Some mandatory disclosure laws are judge-made rules to enforce common law or constitutional rights. Think of the Miranda warning or the so-called Upjohn warnings required of lawyers. Until recently, mandatory disclosure laws were constitutionally uncontroversial economic regulation. But as we've heard, in 2018, the Supreme Court threw all that into doubt in NIFLA by striking down a California disclosure law on the grounds that it was a speaker-based, content discriminatory regulation of speech. Ironically, the day after the court struck down the disclosure rule in NIFLA, it issued a ruling in Janus versus AFSCME Council 31 that depends on the very form of compulsory disclosure that NIFLA struck down. Janus, as we know, invalidated employer labor contracts in the public sector, requiring employers to make payroll contributions to unions on behalf of any objecting union-represented employees by finding that the contributions were compelled speech of the employees on whose behalf the employer had paid the money. This whole dues fees system, of course, depends on the Supreme Court's requirement that unions notify all workers that they represent of their right not to join the union and not to have any fees paid on their behalf. NIFLA suggests, and I'm going to explain why, that requiring unions to inform workers of these rights is compelled speech that violates the union's First Amendment rights. The fact that the Supreme Court didn't even seem to see a conflict between NIFLA on one day and Janus on the next reveals how the court's compelled speech doctrine simply involves the justices picking sides in controversial areas of free speech. So to explain the compelled disclosure on which the Janus rule rests, under the NLRA and under state and local labor laws, a union selected by the majority is the exclusive representative of all workers, including the minority. Although unions selected by a majority gain the right to represent all, they remain private membership organizations that, like clubs or other groups, can impose their own rules regarding membership and dues. But the Supreme Court has steadily limited what unions can do vis-a-vis either their members or the workers who choose not to become members. It has done so at the prompting of a business-funded, self-styled civil liberties organization known as the National Right to Work Committee, which formed in 1955 to combat the spread of unions. Right to Work, as it calls itself, launched a long and highly successful litigation and lobbying campaign challenging majority rule unionism. It won its first Supreme Court victory in 1956 when the court held that an agreement between a railroad and a railway employees union was subject to constitutional scrutiny based on a later discredited theory that federal preemption of state law was sufficient state action to trigger application of the First Amendment to an agreement between a private employer, the railroad, and a private membership organization, the union that represented the employees. And in 1961, to avoid the question whether compulsory payments to the union under the Railway Labor Act violated the First Amendment, the court interpreted that statute not to require dissenting employees to provide financial support for union political speech, but only for costs germane to the union's role as the exclusive representative for collective bargaining. And then in 1977, the Supreme Court extended that principle to public sector unions in Abood versus Detroit Board of Education. In the private sector, where labor contracts involve no state action, the Supreme Court having backed away from the expansive view of state action that launched the challenge to union finance in the 1950s, the Supreme Court held in Communication Workers versus Beck that the Abood fair share fee system, allowing opting out of paying fees, was intended by Congress to apply to the National Labor Relations Act, even though the NLRA's most recent amendments relevant to this were in 1947, 10 years before Right to Work launched its litigation and lobbying campaign, and several years before the Supreme Court invented this whole opt-out structure in the Railway Labor Act cases. This whole system exists because, or compels speech, because in 1986 in Chicago Teachers Union versus Hudson, the court rejected a system that a teachers union had used to handle dissenting employee challenges to the calculation of fair share fees. The court ruled in Hudson that the union provided too little information to employees and left them, quote, in the dark about the source of the figure for the agency fee that non-member union represented teachers were required to pay. The union, the Supreme Court ruled, did not, quote, provide an adequate explanation for the advanced reduction of dues, and it did not provide a reasonably prompt decision by an impartial decision maker, close quote, to handle employee challenges. Accordingly, the Supreme Court required unions to notify all workers that they have the right not to join the union, not to pay dues, not even to pay post-Janus a fee, and that they have a right to contest how the union calculated that reduced fee. The whole point of the Hudson compulsory disclosure regime that the Supreme Court invented was to advance what the court deemed to be the non-union workers' First Amendment rights not to subsidize union speech with which the workers disagree. That has been extended to the private sector under Communication Workers versus Beck, and the National Labor Relations Board under Hudson and Beck has imposed very precise requirements on what private sector unions must explain to all employees they represent, as well as when and how they must provide the notice. And so the upshot is the private membership organization, the union, in the public sector under Janus and in the private sector under Beck, must inform not only its members, but also non-members of their right to free ride on the work that the union does on their behalf. So how on earth does this Supreme Court created system survive the NIFLA rule? And the answer is it can't. Let me explain why. First, under the NIFLA reasoning, Hudson-Beck notices are every bit as controversial as are notices about the availability of reproductive health services and state licensing of facilities that provide services to pregnant women. Second, as to the necessity of Hudson-Beck notices, it is always the case that the government could provide the information itself rather than requiring the union to do so. And of course, that is true about the dues objection notice. The NLRB could provide that information, or the Public Employee Relations Board could provide that information, or the government could prepare posters and send them out to employers to post in the workplace. Or frankly, the employers would be perfectly happy to provide that information themselves, because remember, Right to Work is an employer organization much more than it is an actual employee-funded civil rights organization. Or for all the things that the NIFLA court suggested the government could do to notify pregnant women of their rights to choose abortion. It could send out email or text messages to those who subscribe to NIXL. It could put public service announcements on radio or TV, as the government does during the open choice period under the Affordable Care Act. It could buy billboard spaces, so on and so forth. Third, in NIFLA, the majority suggested that compelled disclosure would be permissible only if the state provided that, or proved rather, that alternative methods of notice were not effective, and California and NIFLA allegedly had not done so. Here too, the same could be said about Hudson-Beck notices. Fourth, the NIFLA majority emphasized that the mandatory disclosure about unlicensed facilities and providers was constitutionally infirm because it targeted only some speakers, not others. That is true, of course, of all compulsory disclosure rules, but as applied to unions, the Hudson-Beck framework requires only the union, not the employer, who is the other party to the collective contract that requires the fee payments, to provide the notice and to administer the complex dues objection system. That obligation could just as easily be imposed on employers, including with respect to how the money is calculated. And remember, it's the employer that pays the money to the union. The workers themselves never do. They never get that money. Fifth, the NIFLA majority was troubled that California required all covered centers to post the notice with the government's precise message, regardless of what the center said in its own advertisements or other communications. That, of course, is true of union notices as well. Finally, and most fundamentally, what both the NIFLA majority and Justice Kennedy's concurring opinion seemed to find most objectionable about the California FACT Act was that the compelled disclosure was contrary to the message that the center wished to convey, or as Kennedy put it, quote, contrary to their deepest convictions. This, of course, is especially true of unions. There is no value more deeply held by unions than the principle of solidarity, building power through unity, pursuing shared goals, and equitably sharing sacrifice. I think the strongest argument, and really the only argument for compelling unions to provide this notice, is the one that was developed by Cynthia recognized when it upheld restrictions on union political expenditures in Davenport versus Washington Education Association in 2007. Unions collect fees and dues from their members because of the power they have as the majority representative. And as the Supreme Court went on to say in Davenport, unions are not spending their own money, they're spending other people's money. Of course, the Supreme Court said that was true about dues paid by voluntary dues paying members, which is clearly not right as a matter of fact. But on that analysis, essentially neither unions nor their members actually have any First Amendment rights because of the possibility that somebody who's paid some money to the union did so only because of a contractual requirement. That's, of course, no longer true under Janus in the public sector. But indeed, it's not even true in the private sector because anybody who doesn't want to pay doesn't have to pay. But I think that's the best argument to distinguish NIFLA. The final point I want to say, and this is really the point that Robert Post developed so eloquently in his lunchtime lecture, is that the inconsistency between NIFLA on the one hand and Janus on the other is in whose speech interests the court considers. NIFLA focused entirely on the speech interests of the organization and gave no interest to the rights of women to hear information. But in Janus, in contrast, the court focused entirely on the interest of the dissenting union represented workers and not at all on the interests of the union as a First Amendment speaker or on the members of the union who are now being compelled, if their union is to survive, to subsidize speech activities that the union engages in on behalf of their free-riding co-workers. And the problem with the whole union dues framework that the Supreme Court invented is that after the court created it in 1961 in International Association of Machinists versus Street, where they recognized that there are free speech interests on both sides, and that's why people could only opt out of political expenditures and not out of expenditures germane to collective bargaining. Not since 1961 has the court given any attention at all to the free speech rights of the unions. And so ultimately, where I come out on this is that the problem with treating compelled notices as a matter of First Amendment right is that the court is always and inevitably choosing one side or the other. When they strike down a compelled notice regime, as they did in NIFLA, they are evaluating only the First Amendment right of the speaker. When they do what they did in Janus, they're valuing only the First Amendment right of the hearer to receive the information, enabling them to opt out. And in the end, I don't think this effectively serves any value that we could all agree on, aside from choosing winners and losers, because as has been pointed out by many, there is no persuasive way to distinguish one case from another. Generally, those who favor less regulation should like a compelled notice regime because it is an efficient and sort of light touch approach to regulation. And third, for the reasons that Robert Post said at lunch, I think it's easy to regard compelled notices as a form of government speech. And indeed, that is exactly what the Supreme Court did in a case called Marquez versus Screen Actors Guild, where it upheld a union's notice that simply parroted the language of Section 8A3 of the NLRA against a claim that the statutory language is misleading because it doesn't really adequately inform people that when they have a right not to be a member of the union, what that means is not even to pay money. And so ultimately, I think the whole compelled speech analysis of compulsory notice is a mistake for the reasons that I have given. Thank you.
Thank you, Catherine. You guys you're staying within the timeline so well, you'd hardly know that you guys are academics. But except the presentations are so good. I definitely know you're academics. We're up to the final presentation of the day. Professor Jane Bambauer and she's going to address us on some puzzles in modern free speech as viewed through the net neutrality and platform bias debates.
Yes, thank you very much. Can you hear me? Can you not? Yeah, okay. So this is a little different, and I feel a bit sheepish because the more I listen to everyone at this conference, including my co-panelists, the more I realize just how much nuance in First Amendment doctrine, and especially some of the cases I haven't read recently, I've really sort of missed and failed to fully internalize. So I'm hoping you all can help me identify any pitfalls in my thinking or logic, or things that have clear analogies to other cases that are not squarely within the net neutrality platform bias debate to help me along in this project, because you're going to be taking some hairpin turns with me. Okay, so first, let me explain the kind of puzzle that I'm interested in. So overall, not only with compelled speech, but speech protections more generally, end users and websites, basically content creators and viewers on the internet, are fully protected. We all know that, we know, right? Platforms and search engines, I'd say the status quo way to think of them is that they are also protected, although this is increasingly contested, even before sort of recent events of deplatforming. This was already a bit of an area of uncertainty. They are, as a practical matter, protected under federal law, federal statute, but the First Amendment treatment has, because of that statute, never really had to be pressed. Internet service providers, while also somewhat controversial, it's safe to say the status quo and dominant opinion is that they are mere conduits of information rather than participants in a conversation. So the analogy for the users might be, the author itself or the reader. The analogy for internet service providers is like a package delivery service where they might be delivering books, but they're just delivering. And then the analogy for platforms, to the extent that there is one, the one that has tended to run the day as something like a newspaper, some sort of curation of what other people are writing, right? And platforms, though, are special because they get all the advantages of newspapers in terms of protections from regulatory intervention, and none of the disadvantages in terms of publisher liability for what's printed, right? So that's section 230 in a nutshell. Okay, so I'm interested in, over time, the difference between platforms and internet service providers, and I'm talking about especially the dominant social media platforms. That's what I have in mind today. That division between them has started to break down a little bit. So let me explain the breakdown. Ultimately, by the end of my talk, you're going to see I'm coming out very mildly in favor of the status quo, but it's a mess along the way. So I do not feel strongly. So focusing on these, are they really so different? Well, okay, so the argument that yes, they are different is that platforms curate with a point of view. So in the case of Facebook, there's a long and fairly elaborate list of standards that are enforced to some messy extent. Other platforms proudly announce that they have that they don't have these community standards and therefore draw a different type of audience and a different sort of content as well. So those standards that are enforced to some measure really do speak a message, right? So Facebook and other platforms that do a healthy amount of content moderation send the message that they are supporting a certain type of speech environment and maybe even a certain type of speech itself. Internet service providers, the net neutrality debate came out of fears that basic ISP providers would be throttling service for certain companies, content providers that the internet service provider itself is in direct competition with. There's a lot of fear that something like AT&T that also creates content would be throttling something like Netflix. Now, it turns out that doesn't actually seem to be a well justified fear. Every time researchers thought they found examples of throttling, it turned out to be much broader throttling, like internet service providers limiting video transmission of any sort, not just their competitors. But still, in any case, even when that's done, and so for pure public policy reasons, I don't know that it makes sense for us to spend a lot of our time and political energy on net neutrality right now. But even if we did want to, I would still say there's no First Amendment implication, because the message from throttling, if there is one at all to be discerned, is we like money, and that's not very expressive. Okay. So now I'm going to muddy the waters a little bit, because increasingly, as I'm sure you knew I was getting to this, platforms like Facebook and Twitter are seen as essential infrastructure for discourse. So you can see this even in Peckingham versus North Carolina, which doesn't actually address the rights of the platform, let me be clear. But when they describe an individual's right to access not just the internet at large, but social media sites, websites in particular, the court writes as if social media is a necessary part of public discourse. So you could substitute in this paragraph I have here the word social media for the internet itself, and it makes just as much sense. Also, I mean, throughout a lot of policy debates about what to do about the dominance of large tech firms, when those tech firms are social media platforms like Facebook, the concern is that they wield network effects. Like if you want a certain type of conversation with connected friends, you're bound to want to be where most of the people are. And so this, the kind of hipster antitrust movement, I know that the phrase is meant to be pejorative. I don't mean it pejoratively here. I mean the movement in conceptualizing what we're trying to accomplish with antitrust law and with competition policy more generally relies on this idea that these platforms are sticky. Okay. So maybe there's actually not that much difference in the sense that we don't have a lot of, as consumers, we don't have a lot of choice. This, I think, was made really clear, though, after the election and before the inauguration, when Twitter decided to permanently, temporarily and then permanently suspend Donald Trump, and of course, many of his most vocal and sort of zaniest supporters. That account suspension bothered people across the ideological spectrum. So, when Erwin Chemerinsky is coming, is bothering to write a public address that basically tracks what Trump and Josh Hawley themselves have been proposing, that there's something here that has real validity. Okay, the second challenge comes from the other direction, though. For those of us in my generation, we're old enough to still think of broadband as the only, reliable way to access the internet, and we all know how we have one or maybe two choices in terms of how we access it. But that's just less and less true as time goes on. Probably the best example is mobile, which at this point many times outperforms, at least where I am, my basic broadband provider. And so if we're just looking at how many choices you have without going any deeper than that, it starts looking like also basic internet service provision has more competition. And so if we wanted to imagine an ISP provider that wants to do filtering for people, to serve some listener interest in having a no porn internet or something like that, it might make some more sense than maybe it once did. Okay. All right. So then maybe they are similar. What does that mean now? Well, okay. So then I think it's time to look at things like Turner Broadcasting to see if must carry rules would apply or not apply to either or both of these. So Turner Broadcasting found that cable service could be forced by the FCC to carry local broadcast channels, because otherwise there would be too much of a risk that they'd exploit their economic power to freeze out those broadcasters in favor of the content creators that they have a direct monetary relationship to, freeze out competition. So the concern, first of all, Congress drew from substantial evidence, and the concern was that without these must-carry rules, there would be significant numbers of broadcast stations that would be not given carriage on cable networks and then therefore not viewed by the people who switched to cable. So even people who actually, who very definitely prefer and want to keep their local broadcast would probably, find the choice of having access to hundreds of channels on cable irresistible. They wouldn't be likely to be switching between antenna and cable all the time. That's burdensome. And so as a practical matter, broadcast competition would die. Okay, so I'm going to assume that basically tracks what today still would apply to basic ISP service provision. Judge Kavanaugh at the time, his dissent notwithstanding. It does not apply as well, I think, to platforms. So if we replace these words here, could we say even Twitter users who want to keep their online contact with Trump and other banned users would probably choose Twitter because of the greater number of users, leading to the demise of, wherever the outcast or dissenting voices wind up, Parler or whatnot? No, what doesn't make sense about that sentence is the idea that we have to choose one and not the other. There is not the same friction that you get when you actually have to unplug. We're thinking about Turner Broadcasting was a while ago, so we're talking about like one coax cable that needs to be unplugged or whatnot. I don't know. Maybe the distinction is not quite as great as I'm saying, but that's how I see it right now. Okay, the other problem is that the proposals for platform neutrality actually are not must-carry rules anyways. They are must-carry rules within a subset of possible speech. So the Chemerinsky and Hawley models both assume that platforms would not be required to carry anything and everything. Instead, they must exhibit viewpoint neutrality. Other types of screening is okay. And so this raises, this raises the difference between viewpoint and content neutrality. Okay, so that means that we're in red lion and tornillo territory because Facebook can, first of all, there have to be hard choices made between what types of things are uncivil versus political and banned for that purpose. In fact, I think one problem with this model that I have is that applying it even to the facts that just transpired after the breach of the Capitol, it's pretty hard to keep that line clean. So if we're in red lion and tornillo territory, then we can look at those. So red lion is the case that permitted the FCC to enforce a doctrine of fair response for radio. But the reasoning was very attached to the fact that there was this natural resource problem that required government coordination. And so because the government already had its fingers involved in giving out these licenses, then it also had the responsibility to make sure that the results of those licensing decisions and the decisions of those licensors wound up replicating a more or less, representative sample of the speech that could be had. Around the same time, the court decided the same is not true for newspapers, because even though newspapers are expensive to run, and in fact, even though at the time of these cases there were in fact fewer newspapers than radio stations, I learned that recently from Genevieve Lakier. Even though all of that is true, it didn't matter because there was nothing that required the law to get involved in managing resources, and so it has to be, tough decisions must be made by markets and norms, not the law. That's sort of my take on how to understand these cases together. Okay, so that's starting to sound like actually at least what we have in mind in terms of regulating platforms or ISPs is actually quite different. So, so maybe they're not similar. So far it looks like, okay, so maybe it makes sense that ISPs or that the manner of regulating that we're thinking of with platforms might have to undergo greater scrutiny. On the other hand, if we think about the burden on the intermediary, the platforms have an advantage, and this goes to a theme that's come up a few times now, which is that they can label and make clear that the content that they don't want to carry is content that they don't want to carry. Now, there's a burden in doing that too, I know, but there could be something similar to the types of warnings that you see all over California, for example, that make clear that it's not really the Disneyland resort that's saying this, it's the state. And even in the abortion context, although I'm not sure how successful it is, I know that at least some abortion providers make sure to engage in counter speech, and occasionally in friendly audiences even mock the disclosures that they have to make. So is the opportunity for counter speech or compelled speech enough to treat platforms and basic ISP services differently? ISP services are at a disadvantage because they can't label which bits they prefer to send and which bits they wouldn't. Or even if they were able to label it, it would only be like super geeks that bother reading the labels. Whereas Twitter, oops, I guess, okay, I'm going to skip ahead for a second. Twitter could do this, right? This is a made up section that I assume will be proposed by Josh Hawley pretty soon. Okay, so we have this problem where when state and private messages are muddled, what do we do with them? And this has come up so much today in conversation that I clearly have some compelled speech cases to learn from. My mind naturally went to cases where it's the state that is trying to preserve its message, and it is allowing some private messages to be sort of supported and supported by state infrastructure, like license plates or a park in Utah, but it doesn't want observers to think that every message is the state's message. I think versus TAM, where this was the challenge to the USPTO office, that found that the band's name, The Slants, couldn't be trademarked because it was offensive. I understand these cases as largely falling on whether the private message is, well, this is a bit too pat, but if the private message might be interpreted as state endorsement, then the government gets to clean up that up. And so it gets treated as government speech. In the case of the band choosing its own name and getting it trademarked, there was no problem. It was pretty clear who was speaking. So the first proposition then is, okay, well, maybe we should rely heavily on this, and maybe it can help with this platform versus basic ISP, whether to treat them the same or not. Now, I put a little question mark though, because I don't feel, I'm saying this because maybe there's some validity to it, but it's a huge burden to, be in, what might be characterized as a private conversation, and then have a state message that you disagree with have to then be not only presented, but potentially rebutted. It certainly changes the course of conversation. And so, and that's well understood. And so I don't know that we can press too much in this direction. If we did though, it would suggest that actually, ironically, maybe platforms could be subject to compelled must carry rules better than an ISP that wanted to do filtering for the sake of something other than just making more money. Okay. Well, here's the other insight. I hope I'm doing okay on time and don't blow it with the, okay, well, I think I'm okay. All right, here's this last one insight. The model that I think generally these debates work with is that all of the information on the internet is out there, and then you have a passive consumer, and then these platforms are sort of filtering mostly on behalf of the platform's own interests, and only to the limited extent that it's sort of commercially necessary for the consumer. And so the consumer is left at the end of this funnel. That's not, I don't think, the best descriptive account of what's going on here. Many times, I mean, I know this is controversial, but I've argued in public that many times even these dominant platforms are really sort of tripping over themselves to try to give consumers a little more of what they want, you know, that red meat, so that they don't spend time doing something else. And so if we think of the type of environment that appears on Facebook or other platforms as something that is kind of co-created with the consumers, where you have an active consumer who's deciding whether they want to be on Parler or want to be on something that is more mainstream, then you could see the consumer as being a little bit more in the driver's seat, and then therefore an obligation to undo some of that filtering that the platform is doing as an impediment to the listener rights. So my second proposition runs completely in the other direction of my first one, that maybe if listeners have ample, you know, access and means to get whatever messages the government is concerned with, and this has come up with NIFLA and other cases, that too should inform how we treat platforms. Okay, those are my mixed up thoughts. Thank you. I'll stop sharing.
Thank you, Jane. We do have plenty of time for questions. I've seen at least one good question in the chat. I'm going to give you people who want to get in line. Please put your questions, or at least get a place in line, so that, or I guess you have to put the question in the chat actually, and Steve will go through that. I'm going to exercise my prerogative, since we have a little bit of time here, to ask questions. And with Catherine, actually, I'll start with Catherine. I buy your argument entirely that Janus and NIFLA are inconsistent. It's a long road to go from Janus through the Hudson compulsory disclosure system to the inconsistency, but I can see that, and I agree with you. I also feel your umbrage that it seems like the unions are always end up on the short end of the constitutional stick. But is the conservative courts remedy here? Do they just say, you know what, Catherine's right, they are inconsistent, the unions don't have to pay for this? The state can require them to give them all the information. The state can then disclose it, or they can let the employers or the National Right to Work Committee disclose it. Now, I agree that saves the unions some money, but in some ways it's not a great solution for unions. Is that all they need to do to resolve their inconsistency between these two cases?
Sure. I think that if there's not going to be the case that's going to get there, but you could reconcile them simply by saying unions are no longer required to notify their members and other workers that they represent of their right to free ride. If the employer wants to tell them that, the employer can tell them that. If the government thinks it's that important and employers aren't volunteering to provide this information, then the government can provide the information. Would this be a better world for unions? Maybe, in the sense that unions wouldn't have to be the ones telling their members, hey, guess what? All that stuff we do for you, you have the right to free ride on it. Mm-hmm. Unions could still tell their members why they shouldn't free ride, but at least they wouldn't be the ones that have to provide the information and pay for the whole process by which workers opt out.
Mm-hmm. Mm-hmm. Great. Now, Charlotte, in your piece, and I've asked you this question before, and you're my fingers on the pulse as to when this is going to happen, if it ever happens. But you pointed out in the introduction of your piece that Janus says that the non-members don't have to pay associational fees, but they are still represented by the union. And at least in my mind, I mean, I know we're not there yet, but is the system of exclusive representation at stake here? Is the Supreme Court at some point going to say, yeah, that's associational too? It's true that you're not paying for anything, but you don't have to be represented by them either. And of course, the system of exclusive representation is bedrock in the American system, both in public sector and the private sector. Is that on the horizon or no?
Well, I mean, there are definitely all sorts of cases out there that raise the constitutionality of exclusive representation. You know, they've universally been rejected, and I think there's a good reason for that. It actually relates a little bit to Jesse's point about when you can say that somebody is reasonably thought to be in association with another entity. I find it just very unconvincing that somebody would think that somebody was associated with a union just because they're covered by a union contract.
Mm-hmm.
To put it another way, you know, I think the Knight case doesn't rely on sort of the Janus line of cases. It kind of exists in its own world where it says, you know, public sector employers can make decisions about who they want to bargain with, and they can choose to set public employee compensation unilaterally. They can choose to, you know, call McKinsey and say, you know, what kinds of wages and benefits will make people want to come work for us and stay for a long time. Or they can say, well, why don't we let employees elect a union, and the union will tell us that information for free, right? Or at least not to our cost, in the same way that the McKinsey consulting fee operates. So you know, in a way, I don't want to sort of put anything past the current Supreme Court, but I really just find the exclusive representation cases to be like very different, and in a way that I'm not sure will have the same appeal to them that the Janus line of cases had.
Okay, you're reassuring. Tell me when I need to start worrying about that. Okay. Although there's a debate that perhaps we'd be better off without exclusive representation.
I had that question. It seems that would solve the free rider problem potentially.
Yeah. There's pluses and minuses to it, I think, for organized labor. Jane, I've got one question for you too, and this is probably more naive because this is not my area. But you know, with the pandemic, I've been watching a lot of TV, and I watched The Social Dilemma, I think it's called, which is about the social platforms and how they are set up. And the very compelling argument is made there that they have taken what could be a tool for free speech and they've turned it into a tool for selling customers, basically. If you're not paying for it, you're the customer. And the argument is made there that, the argument is made there that we ought to reform them so that social media becomes a tool for information, not a tool for stimulating you and sucking you in and categorizing you and then selling you off to advertisers. Now, if the platforms have First Amendment rights, would that interfere with regulating them in that regard, or no? Is that not something we have to worry about?
It certainly would interfere. I think that's a lurking concern no matter what. But even, you know, I guess one reason I don't worry about the interference is that I'm not convinced at what this fantasy of a free service that doesn't have the pitfalls that are described in that documentary, how it will work, what the business model is. Like, okay, so maybe it's not free and we pay, but there's just a, you know, pretty good evidence that people, you know, that people are not willing to get over that hurdle. There's also, I also actually worry about non-behaviorally advertising-based internet content, because there's some evidence from Europe when Europe first implemented its data protection directive. This was the privacy law that came before the GDPR. There's some evidence that when they implemented that, so that tailored advertising was much more difficult, all advertising dollars went down, all spending on advertisement went down. Okay, that's not unexpected. But the really interesting thing is that the websites that were general interest and news, they hurt the most. And the ones where the content itself segments people into pigeonholes so that the advertisers know what type of reader is going to them, those didn't get hurt as much. And that makes sense. And, you know, it's corroborated to some extent by that research. And so I worry quite a bit about the model that people have in mind when they want regulation. Not that there isn't something better than what we have, but it's more difficult than people think.
Okay, We've got at least 3 questions, I think, on the chat. So I'm going to let's go to Steve. Steve, you're going to, Professor Sanders, you're going to help with the questions here?
Sure. Actually, I think one is sort of an observation, but we have 2 questions. And since it's not clear that they're directed toward one person or the other, I think I'll just go ahead and put them both out. And then whichever of the panelists want to tackle them can feel free. And also just to note one thing, I see someone has raised their hand among the attendees. If you have a question or a comment, please put it in the chat. So we can go ahead and relay it to the panelists. Okay, so our alumnus Raymond Halfston says this: given the political composition of the 6-3 Supreme Court right now, what is the probability that this court majority would strike any employer disclosure requirement that employees have no right to work? They are terminable at will. And then let me go ahead and throw out the second question too, from Christian Green. It says, we've been hearing about the nexus of free speech and religious freedom, but particularly in these union and other association cases, is there an associational freedom angle to compelled speech as well? That is there a right not to be associated with speech? So I guess the panelists can have at it with either or both of those questions.
Well, I could talk a little bit about the first one. Would the Supreme Court likely strike down an employer disclosure requirement? So, you know, part of this question might be sort of, doesn't the Supreme Court generally favor employers, and doesn't that mean that the Supreme Court is likely to rule in employers' favor in kind of any given case? But to the extent the question is more about like how NIFLA would interact with an employer disclosure requirement, like, you know, disclose who you think is a ministerial employee. I am not sure that the various definitions of controversial that, you know, Alan was talking about and other folks were talking about earlier could be stretched to reach the employer's statement to reach a required statement that, you know, I think you're a ministerial employee, particularly because it's a statement that the employer would be making because they plan to make that statement again later in litigation. And so it strikes me as hard to say, you know, it's hard to make the case that, you know, it's too controversial for me to have to disclose in advance something that I plan to affirmatively stake my defense to litigation on later. You know, so that's my take on that.
I agree with Charlotte on that. I don't see the ubiquity of compelled disclosures as a form of regulation, especially in the employment relationship. You know, I rattled off some examples, but I could go on and on. It all depends, of course, on compelled speech. And I don't see the Supreme Court having any particular thing to gain by blowing up the Family and Medical Leave Act and the Employee Retirement Income Security Act. You know, and if they want to get rid of the Affordable Care Act, they're going to get rid of it. They're not going to do it by doing something about open enrollment. So I think really what compelled speech has operated as, like the complicity arguments that others have talked about, is that this is an argument that they can kind of pull off the shelf to use for some particular rule that they happen to find offensive. And the huge swath of First Amendment cases and the fact that you cannot reconcile one case with another, that's been true for a very, very long time. And I think they just at some level don't care and don't feel particularly obligated to reconcile the doctrine. And so I don't see this as, I think it'll be happenstance here and there, and law professors will complain about it and accuse them of being results oriented, and they'll be like, yeah, so what else is new?
I have a question about that. I have heard academics make arguments in favor of some compelled speech complicity cases, but I have not actually heard someone give a, anything other than a devil's advocate defense of Janus. Am I just living in a filter bubble, or is there really something different about this case that has just given up on even pretending that there's a boundary between speech and conduct and trying to keep the First Amendment contained?
I think the defense of it is that unions are coercive in a way that is unique. That's not an argument that only the right wing makes. Just cast your eye across leftist public discourse on the subject of police collective bargaining rights these days. And 5 years ago, there were a lot of people on the left who had a lot of bad things to say about teachers' unions and the way in which they didn't serve the interest of students or of teachers.
Yeah, but they didn't make First Amendment arguments. Like I can make the policy I can make an anti-labor policy argument if I understand how to do that in a way that makes some sense, but I cannot make it with a straight face through the First Amendment.
If you don't want to be entirely consistent from one category to another, it's easy to make a First Amendment argument. The problem is consistency. And so I think, one of the comments in the chat was, isn't there a First Amendment associational right at stake when you are represented by a union or sort of affiliated with a union where you don't share their goals? And it would be easy to construct that as a viable First Amendment argument. Think about the police officer who's represented by, the most offensive police union leadership you can think of in the country, who says, Patrick Lynch doesn't speak for me. Why on earth does he get to articulate the views of New York City cops? That's not a unsympathetic freedom of association First Amendment argument to lots of people on the left. It's just hard to figure out how to make that cognizable without blowing up a lot of other doctrine.
Yeah, and I guess I would also, there are definitely some criticisms of Abood, right? Like even long before Janus, there were criticisms of the reasoning in Abood, which is very kind of, we're going to weigh a bunch of competing concerns and try to come up with some kind of reasonable solution. That approach doesn't hugely bother me, but if you're trying to reconcile Abood with other First Amendment doctrine, you could also have some challenges. It's just that in Harris and Janus, Justice Alito decided, well, the thing to do with that is to say that there are First Amendment problems with Abood, and so therefore nobody can be required to pay fees to a union.
Yeah, I thought the facts of Janus were sufficiently different from Abood that you could disagree with Abood and still not get Janus, but anyway, I'll leave it at that.
Yeah, no, I thought one of the interesting things in that line of cases, right, from Harris to Friedrichs to Janus, was the way the union's argument evolved and the way the union was thinking about reconciling agency fees with other lines of First Amendment cases, such as the cases on public employee speech and other contexts. And then, there's this moment in Janus where, Justice Alito is talking about the union making an originalist argument about, public employees not having, free speech rights at the founding. And he's like, well, unions don't make this argument in other cases. It's some kind of waiver argument that a different union didn't argue this in a different case presenting a different issue. So therefore, we don't think unions really mean it now, and we're not going to take the argument seriously. It's quite a moment.
Yeah, and of course, unions have been making First Amendment arguments about picketing since the 1940s and have gotten exactly nowhere with those arguments. And so if you kind of talk to union lawyers now about like, why aren't you people trying to do something about the unbelievable content-based, speaker-paced, viewpoint discriminatory restrictions on labor picketing, they're like, yeah, that'll never work for us. Like, they've just been so whipped at this point by the Supreme Court saying, yes, well, union speech is coercive, including if it's a sign on a stick, and, you know, civil rights speech, that's political, that you can say, you know, I think that is nonsense. That argument doesn't pass the red face test until you're blue in the face. But this goes back to the person who was saying, yes, but they have 6 votes.
Well, are there any other questions or comments? Oh, Robert.
Yeah, I would have thought that the central inconsistency in Janus is Garcetti. I mean, that is to say, if you have no free speech rights when you're talking about the things that agency fees covers, what the hell is the problem with compelled association or compelled? I can't understand it at all. And when you're talking about an inconsistency, it's the right which is pushing Garcetti, and yet the right turns around with Janus. It's impossible for me to understand.
And the court's answer to that, you know, the Alito opinion says, well, the difference is that Garcetti involves the rights of individuals and dues and fees involve group rights, is one of the most ridiculous ways. First of all, it's not true on the facts about government employee speech. But even if it were, that must be the only First Amendment case where they've ever said you have a First Amendment right as a group that you don't have as an individual.
Yeah. And I thought, given what Carolyn said at the beginning about, you know, is paying dues compelled speech to begin with, I've always thought of like attorney's fees, right? You're paying the opposite attorney for things which by hypothesis you don't believe in. Does that get struck down under Janus? Is that really what they're saying?
Yes. And people have been saying this for years. Charlotte has said it in print. I've said it. Lots of people have said it to absolutely no effect. You know, but that's like where they say in Janus, state bar dues are not the same. And literally they say, well, they're just different. Like, it's as close to an argument. It's like, yes, but you know, that was decided on a Tuesday, and the fact that it was a Tuesday is a legally significant distinction. It's an argument that doesn't usually get made in quite so unjustified a way, but they don't have a better argument.
Yeah.
Yeah, I mean, the like my personal like least favorite part of the individual versus group rights thing in Janus is that like Mark Janus was suing over his like $500 a year, right? Like Mark Janus's $500 has zero effect on the budget of Illinois state government, right? And yet, like that's the speech that the court holds is unconstitutional.
Yeah.
Any other comments or questions?
You're gonna. So this is to Jane. I mean, I've never understood the architecture of the internet First Amendment stuff. So I was fascinated by what you were saying. And tell me what you think of this line of thought. So typically in First Amendment doctrine, you consider what's called public function, Marsh versus Alabama. So if the internet is really like a public forum, then it could be put under the obligations to act like the state. And one way to frame the question of whether they can't discriminate is whether they're acting in a public function. And I've always understood the difference between public function and private market to be the difference between voice and exit. So if it's a state, you have a monopoly on power, you can't get out from under it. And so you have only the option of voice, hence voice is protected. Where if it's in the market, you can always choose a different provider, and you can always go from, from Twitter to Parler or whatever. And as long as you have the exit, then it's not a public function, and hence First Amendment protections. It wouldn't be under the obligation not to discriminate as you would of a state. Now, if that's true, is it the case, and I'm asking this as a question because I don't know, is it the case that whether one has voice or exit as an end user or as a website provider turns on traditional antitrust law? I mean, if antitrust law is supposed to tell you whether or not you have a monopoly or whether you have the option of exit, is it the case that we are in effect constitutionalizing antitrust laws vis-a-vis the First Amendment? Is that what's going on here?
I didn't know that took a sudden turn and took me in and takes us into antitrust, which I have tried not to get into, because antitrust itself is it's currently in a state of evolution.
Yes.
And I never really felt comfortable anyways. And I think, it might need an overhaul, but I'm not the right person to think about where it should end up. But I guess there are two things bound up. One is whether there really is, you can have antitrust problems even with a consumer good that is not essential, or not like a utility. What seems to be motivating people here, though, is the sense that we really need to be on certain online public fora, specifically social online public fora. And I have to say, one reason I feel a little uncomfortable even claiming that I sort of understand the zeitgeist of what's happening here is that I just don't feel that way. I mean, I'm just not on social media, and if I were deplatformed, I wouldn't even know. But if that's true, the funny thing about your question is that I had just used the Hirschfeld, I think it is, or no, Albert, who's the voice exit person? What's his name?
Hirschman.
Yeah, Hirschman, that's it, not Hirschfeld, Hirschman. I had just used that in a paper on social media, but I was arguing that what's happening is that on social media, exit is not just the option, it's really not just an option, it's kind of the only option, because voice in the sense of empathetic pushback and difficult conversations is not possible without some of the rules that come along with real life associations and friendships, and just some of the duties that come along that do not get transported into social media. And so there's always an omnipresent threat of exit from everyone you're talking to, and that really distorts how people speak. So it's funny that you're kind of turning this on its head and saying there is no exit.
But isn't that the premise of the argument, that in fact they should be under these restrictions as common carriers? I mean, isn't that the premise?
Well, that's the premise, but I don't buy it yet. I don't buy it, first, maybe because just so totally idiosyncratically, I think life is pretty good without it, and and there's some pathologies going on it, and so there's part of me that even is like for expressive purposes doesn't like it when courts even talk about it that way, or policymakers. But then the other reason is purely descriptively that that people increasingly use several different social media sites, social media platforms, not necessarily websites, at the same time. They use them for different reasons. Also increasingly there's sort of proposals for data transfer, so whatever stickiness there was with just being invested in your data and profile in one, maybe that's going to be eased up. And so that you're really just left with network effects. And for me, that's not enough to call this like the same thing as electricity.
Okay, well, I think we're at the hour, and I think we have some concluding remarks by Reese Sobel from the Journal. Reese, are you there?
I'm here, Professor Dau-Schmidt. Thank you.
All right.
And thank you very much, Professor Fisk, Professor Garden, and Professor Bambauer. At the conclusion of the last panel, I said that I thought this would be yet another great set of speakers, and you all certainly lived up to that statement. So thank you very much. Well, our symposium has come to a close, and it truly has been a wonderful and in many ways an eye-opening day. I felt this way with each one of our panels, as well as the keynote speaker. But I think that if we had unlimited time, the questions and debate and back and forth really could have gone on and on for as long as we let it. So you all have certainly given us a lot to think about. Each one of our panelists, and of course our keynote speaker, Robert Post, have provided a unique and nuanced view of the law in the sphere of First Amendment compelled speech. I feel very safe in saying that I speak not only for myself, but for our journal and our law school as a whole, in saying that we are incredibly proud and impressed with how the symposium went today. So to all of our panelists and to Professor Post, thank you very much for joining us and for sharing your ideas and theories on compelled speech doctrine. I also would like to take a second to single out our organizers once more, Professor Alexander Tessis and Professor Carolyn Mala-Corbin. When you brought us the symposium a year ago, came up to us with the idea, we thought it was very interesting and we were very excited about it. And you both have delivered in every way, bringing us an incredible panel of professors and helping us to organize the event and help it to run smoothly. And we're very happy that you gave us this opportunity. I also want to thank our moderators once more, Professor Susan Williams, Dan Conkle, and Ken Dau-Schmidt. You all did a wonderful job and made some very thoughtful contributions of your own today. Chelsea Browning, I can't thank you enough for making this happen. Running a virtual symposium is not easy, and very few people have a lot of familiarity with the technology and the ability to make these things run smoothly. And this certainly was not a reflection of Caitlin or my efforts. This was all Chelsea in making the virtual format run the way that it did today. So thank you very much. Also, I want to thank our colleague on ILJ, Kristen Canast, as well as Fatiana Hassani in Dean Parrish's office for their efforts in marketing the symposium. And I would like to thank Professor Whitus, Dean Parrish, and the rest of the administration for your continued support and helping to facilitate communication and just overall making the symposium happen. Once more, I want to take a second to thank Professor Sanders. Professor Sanders is in a temporary role this year as our faculty advisor. And I think that he has had a lot more responsibility put on his plate than he may have been expecting, but he has really taken it with open arms and just been invaluable in making the symposium happen. And he's really just been so willing to help out in any way. And we're very, very grateful for everything that you've done, Professor Sanders. And then lastly, Caitlin Klinger, our fearless leader, our EIC. Being an EIC is a big job in and of itself. And I think that most symposiums that have, or most journals that have a symposium have a symposium editor who is dedicated full time to organizing and running a symposium. But our journal, we don't have symposiums very often. It's kind of a rare thing for us. So we don't have that position on our editorial board. So Caitlin has really taken it, mostly on herself to plan everything and be the main modem of communication and just getting everything organized, and everything has really ran through her in addition to her responsibilities as EIC. And she has done a fantastic job on both fronts. So thank you so much. And your hard work has led to a great product today. And one last thing I want to touch on before I turn it over to Professor Tessis to close us out. I really believe that today's symposium carries a lot of value for a couple of reasons. The obvious reason is that the First Amendment is one of the cornerstone freedoms of our democracy. And the subset of First Amendment law that our symposium addressed today in compelled speech is a particularly salient issue that touches many aspects of our lives. Now, the other thing I want to mention is that, in light of all of the challenges that we have faced over the past year, I think today's event carries a special importance. Many events have been delayed or canceled for good reason during the pandemic. But where possible, it's crucial that we find creative and unique solutions to carry on with our lives and continue to move forward as a society. And while we certainly missed out on some of the ancillary benefits of an in-person symposium, I really believe that today's event accomplished all of the primary goals of a legal symposium by presenting, sharing, critiquing, and improving ideas about what the law is and what it should be. And that is something that we should all be able to look back on fondly and with a measure of pride. Now, I know that the articles published in volume 97 of the Indiana Law Journal will reflect the tremendous scholarship that we've listened to and taken part in today. So once more, thank you to everyone involved in putting this event on, and of course, to our esteemed panelists and our keynote speaker, Robert Post. Now I'll turn it over to Alex for some more closing remarks.
Well, I don't have many closing remarks because those were such excellent remarks. It was you put it so well. You left in good, very little for me to say because you did such a great job in summarizing it all. Caroline and I are very grateful to have worked with the Indiana Law Journal. It was such a pleasure working with her, and it gave me so many opportunities to communicate with her and to expand our friendship. And I'm very grateful to everyone here. These symposia are such wonderful opportunities just to bring us together to share ideas. We're left with a conundrum in the end of the day. The doctrine is really a mess, and I'm left with the sense that the court is political, and this is just one area that demonstrates as much. But insofar as we can look at the nuances, look at the specifics, unpackage things, deconstruct them, and try to search where free speech should head in order to achieve the goals of both the First Amendment and of our Constitution and this representative democracy. This is just one of those, and I really hope we'll continue the conversation. Steve Sanders has done an incredible job. I've worked with numerous professors on similar projects, and he has really taken to hand some very difficult organizational issues that he helped us out with, and Caitlin LeBlanc and Reese Sobel were absolutely great. So thank you all, David, Alan, Jesse, Nadia, Caroline, of course, Charlotte, Catherine, and Jane Bauer, and Robert. Thank you so much for those deep words, and thank you for the synthetic way that you presented the entire material. I enjoyed your presentation and look forward to hearing it in the recorded version once that comes out. So I look forward to seeing you all somewhere further on down the road.